very good Saturday morning. It gives me immense pleasure to extend to you a very warm welcome on behalf of Chandigarh Judicial Academy, who has clubbed all of us for this one-day workshop on Juvenile Justice Act. I heartily welcome Honorable Mr. Justice Augustine George Masih, Judge, Punjab and Haryana High Court, and also Chairman, Juvenile Justice Monitoring Committee, Honorable Mr. Justice Harinder Singh Sidhu, Judge, Punjab and Haryana High Court, President, Board of Governors, Chandigarh, Sh.A.K.Sharda, Learned District and Sessions Judge, cum Director Academics, and Dr. Balram Gupta, Director Academics, faculty members, and all our participants for this program. Now, without further ado, I would like to call upon Dr. Balram Gupta, Director Academics, on the stage to have his introductory remarks. Dr. Balram Gupta.
Honorable Mr. Justice A.G.Masih, Judge, Punjab and Haryana High Court, Honorable Mr. Justice H.S. Sidhu, the capacity of officers engaged with the juvenile justice as such. Good morning to all of you. From Nirbhay of 2012 till the passing of the Juvenile Justice Act is a journey which is reflective of as to what had happened in 2012 and how the Indian Parliament, the Indian judiciary, grappling with this particular important domain of juvenile justice. Three different aspects: children in conflict with law, children in need and care, and the third aspect, which is also so very important, the best interest of the child. It is around these particular aspects that the juvenile jurisprudence is developing in that particular context. Keeping this aspect in view, we have organized this one-day workshop, which is divided into 5 different sessions besides the inaugural session for that matter. And the various different aspects are going to be covered during the course of the day. The basic object is to sensitize the different officers engaged in this important exercise so that we can achieve meaningful results in this particular process. It's an ongoing process so that from time to time we are able to engage officers in this particular meaningful exercise. I have great pleasure in welcoming Honorable Mr. Justice Sidhu, Judge, Punjab and Haryana High Court, and particularly the welcome as President of the Board of Governors of Chandigarh Judicial Academy. It's my personal and the Academy, on Academy's behalf, I extend, my Lord, a very warm welcome this morning. Justice Sidhu is a blend of the bar and the bench. Came into the profession in the year 1987. He was the main strength of Punjab AG office for that matter. I have seen myself his contribution during his bar days as to how much he contributed in that particular domain for that matter. It was in the year 2013 that he was elevated. And During all these years, his contribution is so well known. Justice Sidhu symbolizes humility, humility wrapped in humanity. That's the way I would describe Justice Sidhu as such. Sir, we welcome you and look forward to your opening observations regarding the juvenile justice, an overview of the Act. Justice Sidhu, please.
Honorable Justice A.G.Masih, the Chairman of the Juvenile Justice Monitoring Committee of the High Court, Dr. Balram Gupta ji, Director Academics, Sh.A.K.Sharda ji, the Director, Shri O.P. Goyal, Judicial officers manning the Juvenile Justice Boards across the states of Punjab and Haryana, the experts, psychologists, doctors, it is estimated that children below the age of 18 constitute over 40% of the Indian population. The Juvenile Justice Act, which deals with this segment of Indian society, hence its proper implementation is very crucial, not only for them, but also for the health of the nation. Because the manner in which a child in conflict with law or a child in need of care and protection is dealt with at the initial stage as envisaged under the Act would in a large measure determine how he would shape up as an adult. The two most crucial sections of this Act which would be dealt with in today's workshop would be Section 12 and Section 15. Now these also present the most challenging tasks to the juvenile justice boards. Now under Section 12, bail is the rule, but there is a proviso which prevents a problem. Bail may be denied if there are grounds to believe that the child would come in association with a known criminal, or his release would expose the child to moral, physical, or psychological danger, or that his release would defeat the ends of justice. Now, all these things are matters of assessment. How will the assessment be made by the board as to whether the proviso attracted, whether he would come, if released, in contact with a hardened criminal, whether his release would expose him to moral, physical, and psychological danger, or whether his release would defeat the ends of justice. No doubt, the Juvenile Justice Board would be having some report, but that may or may not be determinative. What would guide the Juvenile Justice Board eventually would be the scheme of the Act, the objects of the Act, and the guiding principles enshrined in the Act for the purposes of the administration of the Act. Similarly, the assessment to be made under Section 15. Again, a very challenging job. The mental and physical capacity of the delinquent child to commit such an offense, the ability to understand the consequences of the offense, the circumstances in which the alleged offense was committed. No doubt again, the report, the inputs from the psychologists and the other experts would be there. But again, the determination is at the hands of the board. Now, how does, in these indeterminate parameters, how do you proceed? Now, when a constitutional court is confronted with some such thing, what is the parameter? Parameter would be the preamble, the scheme of the act, the fundamental rights, the directive principles. So in my view, while discharging this function, the board, if the board is guided by the objects of the act primarily being the care and protection of the child, his development, treatment, and social integration, and a totally child-friendly atmosphere. Now, this has always to be kept in the forefront while determining these aspects, and the criminal angle, criminal adjudication angle, would not, to my mind, at this stage, take predominance. I'm sure that the participants at this workshop would be benefited by today's workshop and the participation, and the functioning of the Act would be as per the objectives enshrined in the Act. I wish this workshop a great success. Thank you.
I have great pleasure in welcoming Honorable Mr. Justice A.G.Masih. Justice Masih is not only J1, he is presently the chairman of the Honorable High Court Committee monitoring juvenile justice. Justice Masih joined the bar in the year 1987. I have spent years together at the bar with Justice Masih, and I've seen him in action in court, how diligent he was, how efficiently, skillfully he would be arguing the cases before different courts for that matter. He was also equally the strength of the Punjab AG office for that matter. It was in the year 2008 that Justice Masih was elevated as a judge of the Punjab and Haryana High Court. I recall he had to wait for some time because he was so young that it was thought proper, though I know so many examples that those who have been elevated before the age of 45, but he had to wait to be on the bench. It was in the year 2008. This journey from 2008 till now has been a hugely contributory innings on his part. I have the great pleasure of arguing cases in his court. You know, a lawyer looks forward to a convenient environment in court so that the lawyer can give his best, assist the court effectively. And I'm so happy to share with you all, his court has always been a comfort for the lawyers to argue matters for that matter. I have that particular experience of his court. His contribution is tremendous, and in this particular domain also, in juvenile justice for that matter. More than that, his association with Chandigarh Judicial Academy has been long, meaningful, intimate for that matter. We have learned so much under his leadership as such. The only aspect is that he did not have a good long term to be the leader of the Board of Governors of Chandigarh Judicial Academy. But his association otherwise has been so contributory and meaningful for that matter. Sir, we are very happy to welcome you and looking forward to your inaugural address this morning. Justice Masih, please.
After having heard so many good things about a person, well, it takes time to come back to the normal situation where he should be. Thank you very much, Dr. Gupta. I know it's your love and affection because of which you have said so many good things about me, but I don't know exactly as to whether it's correct or not. Nevertheless, let's start from that. Comfort and the composure in the court. That's, I think, the starting point of any matter when you are dealing with. I'm not talking about the court alone. It could be anything. If you are interacting with someone, if you are talking to someone, that's where, if you are comfortable and the person with whom you are about to interact feels that comfort and confidence to talk to you, that would make a lot of difference. The things will start flowing from there. And that's what I want to emphasize upon to start with. When we are there as a board handling the situation, we are not dealing with hardened criminals or normal criminals, which we generally, as judicial officers, I'm talking about the principal magistrates who are handling, they would have been doing that assignments earlier. But those are people who are different from the lot which we are now dealing with. Why have we put this training on? There are two reasons for that. The first being the statutory mandate, which is provided for in the Act itself. And therefore, we had to do it. But above that, what actually motivated us was, we wanted that through these interactive sessions, which we have proposed, and in fact we have worked it out, you get to not only know the intricacies of the legal aspects, but apart from that, the details and the implementation thereof. Statutory provisions are always there. It's the interpretation. It's the way you look at it that the things start moving from there. Let me put it to you. Generally, if we start a matter with a mind that a young child who has come before you is a rapist, let's take an extreme step. Don't go by the FIR which is registered against him. See as to who is the person who is alleged to have been raped. We need to understand that with the change in circumstances and the society as the exposures which the children are getting, There are all possibilities now open. Just try and put yourself in the shoes of that particular juvenile, that person, that child in conflict with law. Try and understand as to what has forced him into it. Or is it the circumstances, maybe the society, maybe the family circumstances, maybe there can be further situations where people would be exploiting that person. So you cannot generalize anything. You cannot generalize anything. It has to be, therefore, dependent upon each facts and circumstances of each person. Whatever you will hear from here, those would only be guiding principles. Those will only be the guiding principles, the basics. The details you have to carve out. And let me put it to you, there is nothing like stagnation as far as the human feelings and relations are concerned. They vary from person to person, they vary from step to step. Even moments make a difference. So therefore, what I would suggest only is this: be humane. Your approach need to be that. Try and first understand the situation of the child who is in conflict with law, as to how and why such a thing has happened. We generally ignore that. We start with an adversity. We go by the allegations without realizing the other side of the coin is also there. We don't even try to flip the coin to understand the part of the story which would be there. May be true. We have had cases where there has been false implications. Now, the easiest way which has been thought over and had been practiced earlier, was to isolate a person from the society. That's been the general principle which has been followed. But that doesn't work as far as the category of persons which we are going to deal with. And therefore this law, a specialized law dealing with that particular situation. So look at it from that context. Don't think you are dealing with a criminal. They are children who would have, because of certain circumstances in life, reached that stage. What happens generally is that the newspapers play a very important role as far as impressioning the mind of the judge also. We all are humans. We deal with cases. But that's what I would request you all to ignore. Maybe the facts which is pointed out there are not correct. Why do we do that? We can't help it. It's something which is dependent upon person to person, but you need to come out of that stage. Start with a mind which is open and receptive. Unless you are receptive, you're not going to understand a thing. We judges also, and even every person has his own way of looking at things. Please stop looking at things in your way Rather, try and start thinking and looking at things from the perspective of the person who is suffering, not only being a victim, that would be the person who would have filed a complaint against such a juvenile, but the juvenile himself or herself. Why? Why has it happened? I know the psychological aspects would be dealt with in the seminar. We have kept a session for that. But nevertheless, I would only like to emphasize upon that. Society plays a very important role. Where you are born, on which you have no control, on which, and the circumstances in which you are brought up. There may be a person who would have been born in a very poor family. There would be another person who has been in too rich a family. Possibility of both of them ending up with the same crime is always there. The circumstances are different, but the end result could be the same. Why? The real thing which need to be taken care of, therefore, is not only the criminality aspect, the reform, and the future rehabilitation. How many of us think in those terms? Let's start moving in that direction now. The reformist approach has always been there. But now let's be more practical and make them worth recoping with the society, emulging with them with the society, so that they are able to live a life, dignified life, after they move out from what situation they were in. The intent of this seminar is not only to make you aware of the provisions of the statute alone. Statute we all can read. We have a statute available with us. The interpretations would also be known through the various judgments which are pronounced by the courts from time to time. But the real intent of this program is the interactive session. I would want and request all of you that please ask as many questions as you have in your mind. Any doubts which you have in your mind, you need to share. Well, we have the resource persons who are supposed to be experts, but no one knows everything. You must give that leverage to that expert as well. And don't expect the expert or any person who is responding to your question to think in the same terms as you think, because that's a different point of view. Why I am emphasizing upon that is, coming to the original point, each person is different, he thinks differently, and therefore for thinking in those terms also the circumstances would be different for each one. Try and put yourself in a situation where that child in conflict would have faced that situation and therefore reacted in a particular manner. Humanity is always there. But let's now start becoming human. We miss that. Good to speak, lecturing easy, but when it comes to implementation, that is the toughest. Let's change ourselves. Start looking inwards. Instead of finding mistakes with others, try and find something inside which is good. Everyone has it. That poor person who is in front of you facing that situation would have so many beautiful facets in life. His personality will have that. Try and encourage him to bring out those facets. There may be a person who is a very good artist. Bring it out. Encourage him. But what I have experienced is that generally we don't interact with the accused, whoever is there in front. The result thereof is it's a monologue. The judge speaks and the poor person hears. The lawyer or the representative puts forth the case, and the person who is handling, whose case it is not even given a chance to even speak. Please try and talk, especially to these children. Bring them into the system. Don't let them be isolated. हम तो वैसी सोसाइटी में जब भी बाहर निकलते हैं, अगर किसी के अगेंस्ट कोई एलिगेशन आ भी जाए झूठी ही, चलते फिरते सड़क पे उसको हमेशा कहते हैं, वो देखिए खूनी जा रहा है, वो देखिए रेपिस्ट जा रहा है, बिना रियलाइज किए कि उस बेचारे पे क्या बीतती है. Are you by this conduct forcing him to ultimately take that as a part of his character? Let's start thinking in those terms. Let's look at children who are not doing it on their own, but have been put in such circumstances that they were forced to do that, or they were tempted to do that, or they were guided to do that. That's what I wanted to say to you as of now. The details and the legal aspects have been dealt with by my brother, so I didn't have much on that aspect. I wanted to say that, but it has already been said. Wishing you all the best, and I'm sure this training session would make you better persons and acclimatize you and make you prepare you for handling the situations which you are likely to face and are facing in day-to-day working, and the responsibilities which you have taken upon yourself. Thank you very much and wish you all the best. God bless you all.
Let's change ourselves. Let's be more human. Let's start looking inwards. Let's look at children not who are doing it on their own, but they are put under such circumstances, maybe under pressure or maybe tempted to. Thank you, my lords, for your inspiring words. I'm sure your words of wisdom will be the guiding light and will go long distance in dealing with our professional aspects. Now, may I call upon Mr. A.G.Sharda, Learned District and Session Judge, cum Director Administration, for his vote of thanks towards Honorable Mr. Justice A.G.Masih and Honorable Mr. Justice Sidhu. Mr. A.G.Sharda.
Honorable Mr. Justice Judge-cum-Director, Judge Punjab and Haryana High Court, cum Chairman Juvenile Justice Monitoring Committee, Honorable Mr. Justice Harinder Singh Sidhu, Judge Punjab and Haryana High Court, cum President Board of Governors, Chandigarh Judicial Academy, Dr.Balram Gupta, Director Academics, Chandigarh Judicial Academy, and all the participants, good morning. It is a matter of immense pleasure and great privilege for me to propose a vote of thanks to Honorable Mr. Justice Augustine George Masih, Judge Punjab and Haryana High Court, and Justice Harinder Singh Sidhu, Judge Punjab and Haryana High Court, on the occasion of organization of workshop on sensitization of various stakeholders under Juvenile Justice, Care and Protection of Children Act 2015 by the Chandigarh Judicial Academy. We are grateful to your lordships for sparing their valuable time and gracing the occasion and for guiding us. Your lordships, your remarks made today have provided us so much value to our audience, but more importantly, your thoughts will serve as a guidance to us to make this event a success. Our deep sense of gratitude to you for your kind and inspiring words, which are going to encourage us in future events also. Your lordships would be pleased to know that members and staff of the Chandigarh Judicial Academy and many others have proactively and wholeheartedly contributed for success of this program. My sincere thanks to them also. Your lordships, the words are not enough to thank you for your constant guidance and support to us, but at the same time, I too, on behalf of Chandigarh Judicial Academy, assure you that it would be our endeavor to make this program successful and also to organize many more such events under your guidance in future. Thank you.
Well, just one thing which I wanted to share with you, and I wanted you to help us out. And therefore, I jumped the queue and just came back again. I want you all to please give us the feedback. And if you have any other suggestions apart from whatever we have planned it out this time, if you have anything else on which you would like that we should work on and you want some advice on that, or if you want that there should be seminars in future where these topics which you think probably are important and probably has not been dealt with. We know we haven't dealt every aspect. We have only tried to, as of now, concentrate on a few topics which are to be used and which are being used and which would be essential to start with. We'll request you to please give us the feedback. You want any improvement? Yes. Any suggestions for future? We'll be very happy for that, and we would want you to please contribute in this process so that we improve every time. We just don't want that it should be a routine exercise. We want it to be productive, effective, and actually contributing to the cause for which we have all come together. So thank you very much for that, and I'm sorry, I just thought it should be shared with you so that from the very first session, you start thinking in those terms. Each session would be important, and therefore, if you could just jot down a few suggestions or contributions or your opinions on that, that would help us a lot to improve further in this process. Thank you. Thank you very much.
Thank you, Your Lordship. Now, taking up with the first session, which is the procedure to be adopted in conducting inquiry by the board. So now, what would be the general procedure to be adopted in inquiry, which is the place of safe custody,